Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Ann Lipton and I are here today, as always, or as usual. Ann's a law professor at Tulane in New Orleans who teaches and researches securities and business law. She holds up the legal end of our pod.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Before we get into our subject today, we wanted to note that we now have an email address for our little show here, which is, Ann, Shareholder Primacy, one word, no punctuation, at freefloat, one word, no punctuation, .llc. Again, that's Shareholder Primacy at freefloat.llc.
Yeah, so we're thinking that if you guys want to email us any questions you have or things that you would like us to talk about on the pod, we'll sort of, collect these. And when we have a critical mass, we'll start answering questions or talking about requested topics at a future podcast. So yeah,
that's a good point. In addition to questions about stuff we've already covered, or to kind of argue with us about stuff we've talked about, if there's suggestions for subjects that you'd like to hear about, we would love to know that, because we just kind of come up with stuff that we think you'd like to know, but we'd much rather talk about stuff that you'd really like to know. So anyway.
So shareholder primacy at freefloat.llc. You can email us there and we will go from there.
Excellent. All right. So the subject today is, apologies to everybody, but we're back to Tesla and Elon Musk. It's you could teach a whole probably semester.
And people have. There are
a whole semester
there are a couple of professors who have done the law of Elon Musk or the unlaw of Elon Musk. Yeah.
Right. I'm wondering whether you could fill up a whole semester of 4 classes. Yeah, probably not just a single class, but just
no. They do it. It's a class you can enroll in, and it's the whole semester is just Elon. I am not that person, but yes. So,
wow.
Yeah.
Well, anyway, so while there's so many things,
corporate governance innovator is what Elon Musk is.
Right,
So, yeah.
Innovator. Good. I'm sure Delaware loves that. And today's episode about Elon Musk and the law pertains to his forecasts and his predictions. Elon is out there a lot, making guesses, possibly, or forecasts or predictions about how, in particular, the Tesla business is going to do, what stuff it's going to launch, what its financials are going to look like, all sorts of fun stuff like that. So Musk makes all these outlandish predictions for Tesla's future. And that's what we'd like to talk about. Not necessarily the quality of the projections, though that's worth noting, but there's all sorts of legal issues that surround these projections.
Well, yeah.
And
that's tied very much to the quality.
Right. So we would like to interrogate that, to so to speak. Let's talk about these wild forecasts then. There was, just for example, the most recent earnings call last week.
Exactly.
He projected or estimated there would be 1 million with 1 and 6 zeros, robo-taxis, this new product, which is, it could be some version of a car, but I know it's something new on U.S. roads by the end of next year, which would be 2026. I think 2026 is next year, right? I think that's how that works. Right. He also said there will be production of 1 million, 1 with 6 zeros, Optimus Prime robots. That's not a car. If people who don't, maybe if you're a casual follower of Tesla, you may not quite understand. But there's a whole robotics project where there's this kind of humanoid thing that they've been in development for a long time, and he estimates or projects or forecasts there will be 1 million of those in production per year in 4 to 5 years. So in approximately 2029 or say 2030, there will be that much production. So there's 2 examples of these kind of forecasts, which he put in public. He talked about on a
And he
call.
also- yeah, exactly. And he also said that that he'll be able to deliver cars from the factory to the customer by having them autonomously drive across
I missed
the country.
that. I missed
yeah.
it. What?
Yeah. So I think the example was if you're in California and there's a factory in Boston. I think that was the example he gave. That but he basically across the country. The idea being that you order your car and it drives itself across the country to you, and this would also be available by the end of this year.
Oh, by the end of 2025. So that's in 6 months, 7 months.
Yeah.
Wow. As a Tesla shareholder, that thrills me. The idea that there would be that many robotaxis and the idea that they could eliminate so much transaction cost in delivering cars, and even the idea that they would expand beyond their, this kind of routine car business to robotics in 5 years. That's amazing. Wow.
If it were true, it would certainly be amazing.
Oh my God. I can't imagine the trillions of dollars of value that'll be created. But
he's been making the same projections
right,
for
exactly.
years.
That's the problem, is that his
been
credibility is a little shot here.
He's been predicting completely autonomous cars are just 1 year away since 2016.
Right, full self-driving is going to be, perfectly safe.
A million robotaxis on the road next year has been since at least, I think, 2019.
Right.
So these projections, they don't come true. And if they do come true, it's much later than promised and more expensive, like the Cybertruck. He did eventually make that, but it was later than on the timeline, and it wasn't bulletproof, and it can't double as a boat.
Right, exactly.
So there's actually a website that keeps track of Elon Musk's
of his projections. So I didn't know that. Oh, wow.
Yeah, it's called Elon Today. So Tesla obviously is a publicly traded company, and it's actually illegal to lie about things that affect the value of the stock of a publicly traded company. I mean, it's illegal to lie about things that affect the value of any company's stock, but when it's a public company, it's easier to sue. So the question that I keep getting asked is, isn't Elon Musk violating the securities laws with all these ridiculous projections?
And can a shareholder like me sue him?
Yeah.
And so is there some action that I could take in a court that would try to hold him accountable for all these missed promises and forecasts?
And the answer to that is pretty much no. I mean, he may very well be violating the securities laws, but he's largely immune from private lawsuits. On our last show, we talked about the Private Securities Litigation Reform Act, our show talking about Target.
PSLRA.
The PSLRA. It was passed in 1995. At that time, Congress was very concerned that a lot of private securities litigation was frivolous. Shareholders would sue companies for any kind of bad news, and then they'd win these nuisance settlements. Now, leaving aside whether or not Congress was accurate in having that perception, that was the perception, and they passed this law to make it harder to bring securities fraud lawsuits. And one of the signature provisions of the PSLRA is the safe harbor for forward-looking statements, which is exactly what it sounds like.
It's all that boilerplate I see at the end of every frickin' filing.
Exactly. When companies make any kind of projection of the future, they're largely, though not quite entirely, insulated from private securities fraud lawsuits. And the way this works is, first, if a private investor wants to base a claim on a projection of the future, under this safe harbor, they have to show that the defendant acted with actual knowledge that the projection was false. Now, let's be clear. For most securities fraud claims, the plaintiff has to show that the defendant acted intentionally or recklessly. There are some kinds of claims that might even allow negligence. So by saying actual knowledge is the standard for projections, the safe harbor really raises the bar. It raises
that sounds like a really high
it's
threshold.
A really high bar.
I mean, you have to show people's, not just state of mind, but what they've. It's not what they reasonably could have known, but what they knew.
Whether they had a basis, whether they were reckless is not the question. It's whether they actually knew this projection was going to mislead people. And if the defendant is an entity like the company, that means you have to show that the executive officer who approved the statement acted with actual knowledge.
Elon Musk, maybe.
Like Elon Musk. But that's not all. Because even if you meet this safe harbor requirement, and even if the defendant did act with actual knowledge, which is to say the defendant actually knew they were making a misleading projection, they're still immune from a private lawsuit if the projection was accompanied by cautionary language, meaning warnings of the factors that might make the projection not come true.
Okay.
So you know how when companies give any kind of projection, it's usually accompanied, as you say, by these paragraphs of boilerplate that just say this statement is subject to all these risks and uncertainties. Well, those statements, if they identify the major risks that the company faces, will prevent a plaintiff from ever suing over even intentionally false projections.
Oh, so
that
that's
cautionary
interesting.
language
I hadn't really thought about that. Go ahead.
So even if it's intentionally false, if you have this cautionary language warning of the major risk that could cause the projection to not come true, it is insulated under the safe harbor. So this is why the First Circuit actually once called the safe harbor a license to defraud.
Oh, did it really?
They did. Because to succeed...
what a judge, man.
Yeah, well, no, it was a panel. It was the First Circuit. It was 3 judges. To succeed, the plaintiff has to show both that the statement was made with actual knowledge that it was misleading or that it was false, and that there was this absence of cautionary language.
Okay.
And most of the time, these arguments, they play out based solely on the complaint. So what happens is the plaintiff files a complaint that alleges fraud. They get the case started. I allege fraud. And at this point, the plaintiff has no access to discovery. They have no inside information. The complaint is based just on public reporting, news reporting. Maybe they get to talk to former employees, that kind of thing. And the plaintiff alleges the defendant committed fraud. And the defendant almost invariably will file a motion to dismiss. And if the plaintiff can't show that the safe harbor doesn't apply on the complaint alone with no discovery, the case is dismissed and the plaintiff never gets access to additional documents. So most courts usually take one look at this thick paragraph of warnings and say, cautionary language, case dismissed.
You parked your boat in that safe harbor.
Yeah, exactly.
I'm probably not the first one to use that metaphor, no? But anyway.
This is why Elon Musk is maybe not completely safe when he makes outlandish projections, but he's pretty safe. So in fact, Tesla shareholders did bring a claim against him several years ago.
I didn't know that. What was that about?
He projected that Tesla, this was in 2017, and he projected that Tesla would be able to manufacture 5,000 Model 3 cars per week by the end of 2017. And at the time, their production facilities were so unbuilt that they were actually still making cars by hand.
Right. And they had just moved. I mean, they're U.S. I mean, they manufacture in China and so forth. But their original facility was that old Toyota facility in California. I think it was Fairmont. That was abandoned, and they bought it. And so, there was a time. That's when he was famously like sleeping under desks and so
exactly.
forth. And they were trying to get these first models kind of like out the door.
Yeah. Nonetheless, he projected 5,000 per week by the end of 2017. And in fact, according to this complaint anyway, engineers tried to tell Musk. They told him that is never going to happen. We are not at that stage. And he fired them. He fired one engineering party. So just for telling him that they wouldn't actually meet this projection. Nonetheless, eventually Tesla had to admit, and they admitted it, no, we are not, in fact, going to be able to manufacture 5,000 cars per week by the end of 2017. And the stock price fell. And plaintiffs brought a lawsuit saying the projection was false. But guess what? It was dismissed. Why? Because
they had the safe harbor.
One look, the safe harbor. They took one look at all of this cautionary language warning, well, maybe we won't be able to meet our projections. And the case was dismissed. It was this is a case out of the Ninth Circuit. So, I mean,
in California.
I had to say, when I was in practice, I would bring these cases, and I had one case where I strongly suspected the defendants were intentionally phrasing all of their statements as projections of the future, so they could get that safe harbor projection.
Anything they'd say, any question someone would ask,
it would always be like, well, going forward, exactly.
Right.
So, like, in that case, it involved manufacturing of a new drug, and the company was talking a lot about this new drug that it was manufacturing, but somehow in every single conference call, every statement about it was phrased as a statement of the future. They managed to somehow never say anything in the present tense. Do you know how hard it is?
That takes some doing.
That takes some doing, which is why I suspect that they were doing this quite deliberately, that they've been told by their lawyers they were safe as long as they only spoke in terms of the future. And guess what they were? Our case was dismissed. So I don't want to say that there's no way around the safe harbor. So there are a couple of ways. I mean, first,
there's got to be. I mean, I see lawsuits about this. So, like, what do those involve?
Well, first of all, in the statute itself, the safe harbor doesn't apply to all projections. It doesn't apply in the IPO context. So that's part of the reason why
course.
companies try not to make projections in their IPO documents, because they don't get safe harbor protection. And also, if your IPO statements are false, if the statements in a registration statement are false, there's either strict liability or negligence liability. So there's a lot of liability in the IPO context anyway, and you don't get safe harbor protection. So usually companies try to err on the side of caution, and they don't make projections in the context of safe harbors. So this is part of the reason why, in context of IPO. So this is part of the reason why SPACs were so popular. I mean, you remember SPACs going crazy during the COVID lockdown. And that was partly, obviously, because there was a lot of speculation at the time, but also because...
And it was kind of, I mean, at the time, and I was in a SPAC, I mean, it was kind of faddish. I mean, we'll talk about that in a little while. But there were other reasons why. But one reason, and now I understand a little better, why SPACs... And I kind of knew this, but now the statutory and legal context makes a little more sense, is that you can't... You could make... And look, if you're bringing a SPAC to market, a company to market, forget whether it's a SPAC or IPO, you want to, I mean, you're trying to market this to, and I've been marketed to, you're trying to market this to shareholders with all these really rosy, optimistic, I'm investing in a person who's got a real bold vision for the future, and he's going to use words around that. Yeah. And if he uses in an IPO, initial public offering, if he does that and doesn't, do it the right way, they're going to sue his ass off.
Exactly.
For missing them. And the likelihood of missing those forecasts is pretty high. Exactly. Most IPOs kind of don't do so well.
But
SPACs doesn't apply.
It didn't apply at the time.
It didn't apply. It changed.
Right.
Okay.
So SPACs were going crazy. Basically, this was a way to take your company public and be able to make these insane projections to market it to investors like you still get safe harbor protection. But it was so abused, and it became really, like the Wall Street Journal had this whole article in 2022 about every SPAC missing its projection. On average, like their revenue forecast came in 53% below where it had been projected. Right. So the SEC changed the rules. Now, if it's a SPAC, you don't get safe harbor protection, same as with an IPO. But a couple of years ago, that wasn't true, and that was why... or part of the reason why companies were choosing SPAC public offerings. So that's one limit. The other is that sometimes plaintiffs have been able to beat the safe harbor by alleging that the risk warnings weren't meaningful because they referred to hypothetical problems when in fact the problems had already materialized. So imagine the company projects it's going to sell 100,000 units, and then it has a risk warning, and the warning is, well, we won't be able to meet our projection.
Maybe we won't. You're right.
If we lose a major customer. And they've already lost the major customer at the time of the projection. So courts will say, okay, then those warnings are not meaningful, and therefore you didn't meet the requirement.
Because it wasn't actually hypothetical.
Because it wasn't hythetical anymore.
It was actually more factual. Is that
the antecedent? The risk
lawyers
already
is hypothetical, factual. Is that kind of the?
Well, they say hypothetical versus a risk that's materialized. So plaintiffs have sometimes managed to beat the safe harbor protection by showing or alleging with sufficient. Once again, this is all just on a complaint. It's just a complaint.
Right.
They haven't good factual discovery. It doesn't get that. It usually doesn't get that far. But if they can allege sufficient facts to show that the risk warnings were not meaningful because the risks were presented as hypotheticals when they'd actually already taken place, then some courts will allow you to say you don't get safe harbor protection, and therefore the case can proceed. And some courts have given some guidance about what cautionary language has to do to be meaningful. So they've said, for example, good cautionary language should distinguish between different types of risks, so that an investor can tell which ones are bigger risks or more likely to occur.
There's a materiality item.
Well, something like that. Courts it's been really vague, but courts have suggested that what it would take to be good cautionary language. But most courts aren't really that careful about it. They see a big thick pack of cautionary language and they say that's good enough. But some courts at least have suggested that to be meaningful, the risks should communicate which ones are more likely versus less likely, and they should change as circumstances change. So courts have criticized companies when they put the same thick pack of risk warnings out quarter after quarter after quarter.
Without changing any of it.
Without changing anything, even as the risks start to loom larger and the situation changes.
Or as they evolve or whatever, right? Yeah.
Yeah, okay. Exactly. So those are the basic ways that you can beat the safe harbor.
Wow. All right. There's some questions about what investors think about all this we can probably talk about.
Yeah.
Do you want to deal with that. Let's take a break then and kind of handle those in a minute here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we're talking about the PSLRA safe harbor. And I guess where we left off was that sometimes plaintiffs can beat the safe harbor if they show the language was insufficient or whatever, but most of the time it's just it's so hard to do. Once something's in the safe harbor, that forget it. Usually plaintiffs don't even try. And in fact, most of the litigation isn't about whether the cautionary language is meaningful or not. It's about whether the statement is forward-looking.
Interesting. Whether it's
a projection of the future. Because if it's not a projection of the future, it's not subject to the safe harbor, and you have sort of the ordinary rules.
So going back to our example, there's potentially something worth examining, like is Musk's forecast of 1 million units of robo-taxis. That's probably trivial for our purpose, but is that in fact a forward-looking statement?
Exactly. And these can get really philosophical about what do we mean by the future. So, for example, one of my favorites, if a company says it's on track to meet goals, is that a projection or is that a statement of the present?
A statement of
the present conditions?
Empirical fact today. Yeah, right.
Yeah, exactly.
Okay.
And the case law is actually mixed on that, although in recent years they've trended towards calling that a projection. But I mean, those are the kinds of fights you have. And sometimes you can see courts really straining to take statements out of the safe harbor if they think the plaintiffs have a compelling case. Because they don't you can see some degree of motivated reasoning. So for example, there have been 2 cases, not one, but 2, where Vista Equity Partners, the private equity firm, they've bought out these public companies. And then in both cases, the companies were later accused of kind of intentionally lowballing their projected future performance as a way of making Vista's offer look good so that the shareholders would vote in favor of it.
To approve it.
Yeah, wow. Exactly. So there have been 2 cases like this. And courts obviously were, I think, what emanates from the opinions is that the courts really didn't like the way that these companies were taken private. And so they found ways to recast the claims so that they weren't really projection claims. So in one of them, MindBody, and we talked about the Delaware version of MindBody.
I remember that, yeah.
Yeah, we talked about it, the Delaware version from a fiduciary duty standpoint. But there was also a federal version, which was a securities case, where the company lowballed these earnings projections. So the accusation was that it lowballed its earnings projections. It knew that it was understating what its earnings would be, and that made its stock price go down. So that made the buyout offer look better. And what the court held was that, they wouldn't let the plaintiff sue over the projections. But the court said that the proxy statement was misleading when it said that Vista was offering a 68% premium to the stock price. That statement was misleading because it suggests that the stock price was accurate and that therefore the 68%.
When in fact it had been subject to some subtle manipulation.
Exactly. So it suggested that the defendants believed that the stock price was an appropriate measure of the company's worth, so that the 68% premium was meaningful. And because the plaintiffs had appropriately alleged, in fact, the defendants knew that the price was too low of the stock, therefore the 68% premium statement was misleading. So the court allowed the case to proceed on the grounds that saying that there was a 68% premium was misleading, and the case settled after that. So, but that just goes to show kind of straining to to allow liability for what functionally was a misleading projection. And more recently, the Ninth Circuit, another Vista acquisition, the company had this is a Ninth Circuit case where the company had a business model of acquiring other companies. But when it gave its most recent set of projections, it left out any gains from acquisitions. And it didn't tell shareholders that its projections were being prepared differently than they'd been prepared in the past.
So they changed the methodology and didn't disclose it.
Exactly. And they didn't tell it. And of course, that made its projections look weaker, so the
Right.
company's stock price was lower. And the Ninth Circuit, again, held that the projections themselves were subject to the safe harbor, but what wasn't subject to the safe harbor were the company's representations that the projections were prepared on a reasonable basis and reflected the best currently available estimates. So the
Right.
shareholders couldn't sue over the projections themselves, but they could
Right.
sue over the company's representation that they had been prepared appropriately.
Yeah, right. So the basis for preparing the projections
Because that was a present statement. That wasn't a
was
projection
something
of the
to
future.
litigate.
And because that wasn't subject to the safe harbor. And there have been a couple of cases like that where the shareholders weren't allowed to sue based on the projections, but they could sue based on the statement that our projections were prepared reasonably.
Right.
So this really goes to show, I think, courts but they don't do it all the time. They do it when they think that they have a case that they just, I think, when they're very troubled by a particular set of facts.
by behavior that's particularly egregious, not in terms of making reckless. Because reckless, my word, forecasts are protected, basically.
Reckless forecasts are protected if you have these.
Right.
So they find a statement that isn't a forecast and they allow the lawsuit based on
because there's all sorts of other representations companies make in their to shareholders that come before a forecast. Yeah. And those are all the different things that get litigated. And then the companies start to say, oh, no, that was part of my forecast or something.
Yeah, exactly. That's exactly it. So that's where the fights. So when you're having these safe harbor things, it's possible to beat the safe harbor itself, to say, like, essentially that it's not protected projection. But it's much more likely that the plaintiff will try to say that it's not a projection at all. And, courts will find ways, if they like the case, which isn't always, or rarely, they have found
to
ways.
work with that. Yeah. Well, interesting.
So, yeah, but but that just leaves my question. Like, given that these are unusual cases, the vast majority of the time, if it's a projection, you simply can't sue over it. My question to you is, how are investors thinking about these projections? I mean, they're uncertain anyway, but there also isn't really liability, which means companies can say whatever they want. I mean, the SPACs being maybe there can be SEC enforcement, but you don't really see that.
No, that's not right.
So how do investors deal with this?
Like investors like me.
Yeah.
Let me distinguish investors like me from some other investors. I'm I like to think of myself as, I'm activist, but, I kind of focus on this stuff and I kind of think about it more critically. Most investors don't, they understand that there's forecasts out there, but they don't understand any of even real sophisticated portfolio managers aren't necessarily going to wonder, okay, is this subject to the safe harbor? So I can sort of speak a little more from my learned experience about this stuff. We think about, listen to, understand, or hear these forecasts, and then apply kind of 2 or 3 different kind of filters to it. Okay, the first is, we're not really suing people over.
Yeah, exactly.
Okay,
you couldn't if you wanted to.
And in this case, what we're learning is it would be really hard to sue over this one. But most at least activists, and a lot of most shareholders too, but certainly most activists aren't prepared to start to litigate what they've heard. There's been an uptick in litigation from activists over all sorts of interesting stuff, over advanced notice bylaws and over board structures and all sorts of fun stuff. Okay, worth noting that's mostly at the state level. Okay, but anyway, and so I'm actually working on a couple different projects where I'm working on a project now with a friend of mine, and there's a chance that the company we're working on is screwing around with its capital structure and issuing some shares in ways that we don't like. So we started looking around for a lawyer in the state. It's a state we haven't been in. It's not I can't really say, but it's not Nevada, Texas, or Delaware. It's another state, and trying to figure out how its securities laws work. Anyway, there's been this uptick in litigation. Okay, and again, we can spend a whole other pod talking about why that is and how that works and who's doing better or worse. But there's very little thought to suing companies, whether or not we could. Whether or not we understand about the safe harbor, it's just not something that we're going to sue over much. But that gets to sort of another filter here, which is we kind of understand that these forecasts are, there's different kinds of forecasts we look at. Okay, some of the basic ones that we kind of listen to a little more seriously are like quarterly forecasts, guidance, it's called, right? Where, a company says, okay, next quarter or this year, this is how we estimate our earnings per share. And, all companies are different about how they, what kind of statistics and metrics they forecast on. And some don't. Apple famously doesn't give any kind of forecast out. Tesla does a little. Amazon is a pretty rigorous forecast. So does Walmart. Anyway. But we for guidance, that's something that we know that the companies put a lot of thought into that. There's a lot of modeling, there's a lot of experience, and that tends to be pretty reliable. In fact, that's so reliable. A while ago there was always accusations that the whole sell side analyst community, wasn't doing any work. They were just kind of copying and pasting company forecasts and maybe doing a little bit of kind of waving their hands over it. So there's those kind of forecasts. And then there's a forecast we started talking about, like, Elon's forecasts.
Yeah.
Okay?
So it's a question of just building up credibility.
Yeah. Again, forgetting the fact that he's, fail. And that also matters. If a company has a history of meeting its kind of forecasts, we kind of take that a little differently. But this kind of stuff, we're not in, I'm a Tesla shareholder, but a lot of other Tesla shareholders are in it not because they're relying on and are thinking of holding Tesla to these forecasts of 1 million robotaxis by the end of 26. Okay, no. That's part of the entertainment value, or that gives them a thrill.
I don't think anybody believes it.
Right, exactly. But you ask the question, why is that? And it has, the safe harbor is nice to kind of. Or understanding is kind of helpful, but it's not going to change anybody's view of these forecasts. It's not going to really affect, how investors, allocate capital because of it. Again, the forecasts related to guidance and so forth are a lot more, I guess, credible because there's a lot more thought into it. Going back to, Optimus Prime. We know that there's a huge amount of technical investment that's gone into that, but no one really thinks that there's been any kind of market forecast about what's the demand going to be in 5 years for a robotic butler in your home. I mean, it's just no one cares. So that's we got bigger things to kind of analyze and worry about other than these. And again, it's not just Tesla. There's others. That come out with some of these stuff, but again, most bigger, larger cap companies tend to be a little more careful than Tesla. And it's hard to be careful with Elon, though we can, this past week seemed to show that maybe the board's getting a little spine here. But anyway, we'll talk about that. A lot of smaller companies, smaller caps, and that's where I do a little more of my work. They're not out there making these kind of wild forecasts and so forth. They tend to be, in kind of more niche-y kind of markets and so forth that are much easier to understand. Go ahead. So
it's more like you have a sense of like which forecasts the company itself is taking seriously, and those are the ones that you take seriously.
That's a great way to put it, actually. And we kind of take our lead from that. There's I kind of knew about the IPO thing, and then reminded me about the SPAC situation. Again, we particularly with an IPO or a SPAC, the new company like that, we're going to have to rely some on what the company says about what's going to happen in the marketplace, something like that. For those are new products, new markets, new niches, new whatever. So we're gonna have to there's not like this long history of the company credibly or not credibly making forecasts and meeting or beating them. So in terms of like forecasts around deals and so forth, we tend to be we'll be a little more skeptical. But that's also the last comment I'll make here is that I tend to be fairly critical of this stuff. So even some of the most credible companies, larger caps and so forth, when they come out with some sort of even guidance, we sort of say, we gotta, give that a little haircut or something like that. We're gonna discount that a tiny bit because we just know that they're going to be a little more aggressive, and investors are probably going to be a little more conservative about this stuff. So that's some perspectives about how investors think about these forecasts that we've been discussing. I think getting back to the main point is that we're just, the people who litigate this stuff aren't going to be activists. A lot of it has to do with, a pissed off shareholder that's not necessarily an activist.
Yeah,
or, frequently, in the shareholder derivative or class action world, there's a law firm that kind of puts this together. And finds
the law
plaintiff.
firm sort of usually they have standard clients. They have relationships with large institutional
shareholders,
index investors, things like that, and they'll approach them to see if they're interested.
Does that kind of answer a little bit the question about how investors kind of work?
No, it's sort of the market at work.
Yeah, exactly. It's the market at work. So anyway, wow, this is a very thorough examination here of Elon Musk's forecasts under the law, under the PSLRA. I love saying that, PSLRA. I think we can probably move on at this point, can't we?
Okay.
So let's remind our followers here that we have we're accepting your questions. It's shareholder primacy, one word, no punctuation, at freefloat.llc. So please send us whatever bugs you about what we've been talking about or things you want us to talk about. And then when we get enough of these, we will put a show together for that, okay?
Okay.
All right. It's terrific talking about all this. We will probably return to Tesla again at some point, maybe as soon as next week. Who knows? This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. See you soon.